Welcome to the Deep Dive, where we cut through the noise and get right to the heart of what's truly shaping our world. Today, we're plunging into a really fascinating and incredibly high-stakes legal battle. It shows us how the rapid advancement of artificial intelligence isn't just creating groundbreaking innovations, it's also sparking these, well, incredibly complex legal disputes that are going to define the future of this entire industry. We're talking about a pivotal case that hit the courts back on July 5, 2024. It's the lawsuit filed by XAI Corp, Elon Musk's AI company, and they're suing a former engineer, Liang Gao. The central allegation here is, well, it's massive. XAI claims that Gao, right before resigning, compromised company security. How? By improperly downloading over 300,000 confidential files. And get this, that apparently included the complete source code for XAI's Grok language model. Then, almost immediately, he joins a direct competitor, OpenAI. So our mission for this deep dive isn't just to report on some corporate spat, no. Think of this as a crucial case study. It's a window into the intense, often brutal challenges of protecting intellectual property, especially in an industry where knowledge isn't just valuable, it's literally the most powerful asset. This case pulls back the curtain on the fierce competition for specialized talent and the deep ethical dilemmas that pop up when individuals with access to cutting-edge tech change loyalties. We're going to unpack these allegations, the legal framework they operate within, the digital evidence that's being presented, and crucially, what it all means for you, for future employees in this field, and really for the entire AI landscape. Let's unpack this because, wow, this isn't just about one engineer. It's part of a much bigger story, wouldn't you say?
Oh, absolutely.
Yeah.
It absolutely is. This lawsuit doesn't happen in a vacuum, not at all. It's set against this backdrop of intense, almost existential competition for talent and technology within the AI sector. Stakes are incredibly high, not just for the companies involved, but really for the trajectory of AI development itself.
And the backstory here is absolutely essential to understanding the full weight of this. Elon Musk, as many of you probably know, was actually a co-founder of OpenAI way back in 2015, right, when it was set up as a nonprofit. But he left in 2018, and it wasn't exactly a quiet exit. There were significant, pretty well-publicized disagreements over the company's direction.
That's right. Musk has been quite public, quite vocal with his criticisms of OpenAI, particularly after its partnership with Microsoft and its transition to what they describe as a profit-capped model. He's repeatedly argued that this move betrayed the company's foundational open-source mission, diverging from its original goal of developing AI for the benefit of all humanity.
And that's where XAI comes in, right? Positioning itself sort of as a counterpoint. With its Grok model, Musk's company is often seen as presenting itself as the, quote, truthful and open alternative, harkening back to that original OpenAI vision. So, considering this deep-seated rivalry between Musk and OpenAI, how much do you think that personal and ideological context influences how XAI is pursuing this case, rather than it being, a purely detached corporate dispute?
That's a crucial layer to peel back, definitely. While the core allegations are about trade secrets, the historical tension between Musk's vision for OpenAI and OpenAI's current model. It undeniably adds intensity to this entire situation. It frames this legal battle not just as like a financial loss, but as a fight for the very soul and future of AI development. It makes the stakes feel much higher than a typical intellectual property dispute. It provides a powerful narrative backdrop, that can sway public and maybe even judicial perception.
Okay, so let's get into the heart of the allegations then. What exactly does XAI claim happened here? Who is Liang Gao and what's the core accusation? Boiled down.
Right. So Liang Gao was a software engineer on XAI's AI infrastructure team. This means he had legitimate, authorized access to confidential code repositories. We're talking the absolute nerve center of XAI's intellectual property. XAI presents a narrative of what they describe as a premeditated and clear breach of trust.
And that access is absolutely key because the accusation is that in the days leading up to his resignation, Gao allegedly downloaded a truly staggering amount of data, more than 300,000 files and lines of code, to his personal device. And this wasn't just any data. It included the complete Grok model code and its neural network architecture.
Wow, that sounds like the absolute crown jewels of the company.
It absolutely does. And what's particularly striking here, and a really crucial piece of potential digital evidence, is how specific the method of data transfer appears to be. XAI highlights the alleged use of a command called git stash.
Not git stash. Okay, explain that. Sure. So for those less familiar, a standard git pull or git clone command that syncs changes with a central repository. And it typically leaves a pretty clear, traceable record of a mass download. But git stash, it saves local changes on the user's machine. Effectively, it creates a temporary, isolated copy of modified files without pushing them to a shared server right away. XAI interprets this as a deliberate attempt to evade detection by avoiding a direct, traceable mass download from central servers. It's kind of like meticulously packing a discrete personal bag rather than openly loading a large moving truck, you see.
Wow. Okay, so it's not just what was downloaded, but how it was allegedly done in a way that suggests maybe a desire for concealment. And then there's the timing, which seems critical. Immediately after his resignation, Gao started working for OpenAI, specifically in their machine learning infrastructure analysis team. XAI argues it's almost impossible that Gao wouldn't share or use their trade secrets in this new role. Given the clear overlap in expertise and, well, the direct competitive relationship, that immediate transition seems incredibly damning, doesn't it?
That direct and immediate transition is indeed a significant, perhaps the most significant, part of XAI's argument.
Yeah.
It raises serious questions about the intent behind the download. They also point to a breach of contract. Gao signed a standard industry agreement, a confidentiality and invention agreement, or CIA. Most tech workers sign these. This contract legally obliges employees to keep sensitive information confidential and, crucially, to return it upon termination.
Yeah.
XAI alleges a clear violation of this fundamental agreement.
And beyond just the contract breach, the term malafide comes up in the allegation. That's a legal term suggesting bad faith, right? Deliberate dishonesty.
Exactly. Malafide means bad faith. So XAI views Gao's actions as deliberate and concealed, not accidental or some mere oversight. It's portrayed as an intentional act to steal intellectual property right before moving to a direct competitor.
Okay.
Precisely. The intent, or the lack of it, will be a central point of contention in court. This isn't just about files went missing. It's about a very particular method of data handling, combined with a specific timeline that XAI claims points directly to malicious, premeditated intent. The git stash details specifically, if proven to be used for mass exfiltration like they claim, could be incredibly powerful in showing that intent.
Now, this case truly pushes the boundaries of legal precedent, it feels like. Defining a trade secret has always been complex, but how does the law even begin to grapple with something as intricate and, well, evolving as an LLM's architecture? What framework is XAI actually using to protect these digital assets?
Right, it's a great question. The primary legal bedrock for XAI's claim is the Economic Espionage Act, or EEA, from 1996. This is a federal law, and it criminalizes the appropriation of trade secrets with the intent to benefit a third party. It's a powerful and serious tool in these types of disputes. It elevates them beyond just, civil matters potentially.
Okay, the EEA. So how does that law actually define a trade secret in this context? Because like you said, an AI model isn't exactly a physical recipe or a list of customers. It's far more abstract.
Good question, and it's where the nuance really lies, legally speaking. Under the EEA, for information to be considered a trade secret, it has to meet 3 specific criteria. First, it must not be generally known or easily accessible, obvious enough. Second, it must derive independent economic value from its secrecy. So it's valuable because it's secret. And third, and this is often key in litigation, it must be subject to reasonable efforts to maintain its secrecy. Think of it as a 3-legged stool. If any leg is missing, the claim falls apart.
Got it. And XAI's core argument is that Grok's underlying code, its neural network architecture, its training data, all that clearly fits these 3 criteria.
Precisely. And for a court, the most compelling part of that argument often comes down to how they demonstrate those reasonable efforts to maintain secrecy. We're talking things like stringent access controls, mandatory non-disclosure agreements, 2-factor authentication, sophisticated digital tracking, all of which XAI claims were rigorously in place to protect its core IP.
Okay, what about OpenAI's role in all this? They're the new employer, but XAI isn't directly accusing them of, instigating the theft, right? It's more nuanced.
Correct. OpenAI has publicly stated that it does not solicit or need confidential information from other companies, which is, a standard and legally prudent position to take. However, the law in this area can be quite subtle. A new employer could still potentially be held responsible if they know or should know that an employee possesses and uses trade secrets from a former company.
Ah, the know or should know standard.
Exactly. This means even if OpenAI didn't explicitly ask for the information, if they had reason to believe Gao possessed it, maybe saw evidence of it in his work, and then benefited from his work using that knowledge, they could still face legal repercussions.
Yeah.
It creates a significant due diligence burden on companies when hiring from competitors, especially direct ones.
Right. If we connect this to the bigger picture, it really highlights a growing challenge for the courts, doesn't it? They'll need to grapple with deeply technical concepts, Git commands, transformer architecture, the very nature of model weights, to deliver fair judgments in these types of cases. This isn't just about legal theory anymore. It's about forensic digital analysis.
Absolutely. The evidentiary trail in this case is almost entirely digital, and it sounds incredibly specific. The hard evidence includes things like granular network logs. Think of it as a digital security guards report, showing the exact timestamps, IP addresses, potentially destination for every file transfer. And from their version control platform, likely something like GitHub Enterprise, they'd have a detailed ledger, who accessed what, when, and the sheer volume of data Gao's account pulled down. It's like leaving digital breadcrumbs that tell a very specific, detailed story about what happened and when.
So the company has a digital paper trail showing when, how much, and potentially how data was accessed. And again, that git stash command seems so crucial in their telling.
It is. The git stash command, if proven to be used for mass data exfiltration like XAI alleges, it becomes incredibly powerful circumstantial evidence. It suggests a conscious, deliberate attempt to obscure the transfer of this data. It's a detail that lends significant weight to XAI's claims of intentionality. It turns what might look like a simple download into a potentially much more nefarious act in the eyes of a judge or jury.
And the sequence of events, the big download, the quick resignation, the immediate move to OpenAI, it paints a very deliberate picture. How heavily do courts lean on such a tight timeline as evidence of intent? Or is there still a need for more direct proof, like evidence he actually used the code at OpenAI?
Well, direct proof of use is always the gold standard, but it can be hard to get. So such a compressed and logical timeline, like we see alleged here, becomes incredibly persuasive circumstantial evidence. It places a significant burden on the defense to offer a credible, innocent explanation for that rapid succession of actions. For example, if there were a gap of several months, or if Gao had moved to a completely unrelated industry, the argument for intent would be much weaker. But here, the close proximity makes it very difficult to argue mere coincidence.
Okay, so let's step back. What does this all mean for you listening? Whether you're working in tech, maybe considering a career in AI, or just fascinated by its future, this case sets a precedent that touches everyone, far beyond just these two companies.
Yeah, this isn't just a legal skirmish. It really feels like a foundational shift. A shift in how we understand and protect digital assets. For decades, the classic example of a trade secret was, the Coca-Cola formula, a tangible secret recipe. But this case argues that an LLM's intangible architecture, its model weights, its very brain code, is equally protectable and equally valuable. It's a legal recognition that in the AI age, raw, proprietary knowledge itself, not just a physical recipe, is the ultimate proprietary asset.
Yeah.
It fundamentally redefines what value means in the eyes of the law for this industry.
That's a huge shift in perception and protection, definitely. What about the impact on talent mobility? In Silicon Valley, people often jump between companies, right? That culture of movement has fueled innovation for decades. Does this chill that?
The tech industry is absolutely about to feel the tremors of this legal battle. I think so. Companies are highly likely to significantly enhance their security measures. Things like closer monitoring of employee activity, more restrictive access protocols, stricter download restrictions. Imagine an AI researcher, maybe someone used to a culture of sharing and mobility, suddenly facing a gauntlet of new legal clauses in their contract and maybe more digital surveillance. Companies might start implementing real-time alerts for unusual download patterns or even require code reviews for any large personal backups. It fundamentally changes the trust dynamic, I think, in a way that hasn't really been seen before on this scale.
So, for employees, especially technical ones, constantly working with code and data, a serious word of caution is needed here.
Absolutely. Technical employees must be extremely cautious when changing jobs, especially moving to direct competitors. Even without malicious intent, downloading large volumes of confidential data right before resigning. That will be seen as a maximum red flag by former employers. And it can lead to severe legal consequences even if actual use of that data isn't immediately proven. What might have once been seen as just professional development or even diligent note-taking could now be scrutinized as potential IP transfer. I remember a colleague who used to keep a personal wiki of code snippets and architectural patterns gleaned from various projects over years, just for reference. Under these emerging precedents, even that kind of practice, if it involved proprietary code, could be seen as a huge risk now. The line between personal knowledge and proprietary company information is definitely blurring.
This sounds like it's going to intensify the so-called war for talent even further. Not just for acquiring talent, but for retaining their knowledge, preventing it from walking out the door.
It certainly does, yeah. The case underscores the fierce competition for top AI talent. Companies aren't just vying to hire the best. They are clearly prepared to litigate aggressively to prevent their expertise and proprietary knowledge from migrating. We might see an increase in things like non-compete clauses, where legally possible, longer gardening leave periods, more sophisticated internal monitoring systems. The cost of losing a key AI engineer now potentially includes a multi-million-dollar lawsuit. That makes talent retention an even higher strategic priority.
But this also presents a real challenge for the entire industry, doesn't it? How do you balance the crucial protection of intellectual property with the need for free talent mobility and the open collaboration that has traditionally fueled innovation in Silicon Valley? It seems like a fundamental tension.
It really does. And this raises an important question. Can the industry maintain its breakneck pace of innovation if companies become too protective? And how will individuals navigate this increasingly scrutinized professional landscape? Overly aggressive policies could inadvertently stifle the very innovation they seek to protect. Fear of lawsuits might discourage experimentation, cross-pollination of ideas, and even the natural evolution of talent moving between firms, which often sparks new thinking. It's a really delicate balance, and the outcome of cases like this one will likely dictate which way the pendulum swings in the coming years.
And that's exactly what we're left to ponder, isn't it? The XAI versus Liang lawsuit is a powerful microcosm. It reflects these larger battles being fought over intellectual property, business ethics, and technological competition. Battles that will define the next decade in AI.
It truly is. Its outcome, whatever it may be, will have ripple effects across the entire technology landscape, setting new standards, new expectations for both companies and individuals.
So, the final thought to leave you with. As AI continues to evolve at this breakneck speed, how will the legal system, which was really designed for a different era, adapt? How will it handle the unprecedented complexity of protecting digital assets like neural networks and model weights? And maybe more importantly, what impact will this tension between proprietary knowledge and the free flow of talent ultimately have on the very nature of innovation itself? That's something to think about long after this deep dive ends.